Hello everyone, this is Prem. Since the COVID hit us, we changed our style of working and even learning. And since then, there are a lot of online classes that has been introduced, especially in field of law. We have a lot of students now can learn a lot of diploma courses through online classes. I mean, from across various education companies that just came up, and 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 this came as a good opportunity for those online education company. Two most prominent are the LawSikho and the Lawctopus. You can see they have a huge variety of courses from arbitration, maritime law. You have contract, you have criminal litigation, and it's range from around 5,000 to 20,000. But the thing what made us question is the courses in the litigation. Now, even this company are somehow have convinced that even the litigation can be learned through online classes, and thus the question comes is how it can substitute the practical learning, or is it a substitute? Uh, so this so this is the topic we came up with, is business out of litigation courses, and today we have a distinguished speaker, Joel. He's an AOR in Supreme Court of India, and since he's practicing in Supreme Court and the litigation, everyone wants to practice in litigation in Supreme Court. Supreme Court being like it's a premium place, premium institution that everybody wants to have the name, practice on that court. So without any further ado, Joel, you can continue.
Hi, Prem. Thanks for inviting me for this conversation. The topic is definitely new, and it is definitely interesting. I would like to begin by saying that these courses are definitely an improvement over the way that we as law students were initiated into the practice during our days. We were dependent largely on word of mouth of our seniors and their experiences, their lived-in experiences in the profession. And this is what took us into litigation. Their inspiration, their experiences, and what we read about it in the papers, etc. And if we compare it to that, we see that there is definitely an improvement. I say that there is an improvement for the primary reason that there is much more information that is available when one takes part in these courses, by way of at least knowing the names and areas of practice, the codes of practice, and getting generally a broad overview of litigation as such, and also of litigation in different cities, which might otherwise not be possible simply by going by word of mouth. The kind of overview that a course might provide to litigation is rather unparalleled. But that being said, there are some shortcomings which are there, some pitfalls while joining these courses, which might confront a law student or, for that matter, an early practitioner who might be interested in taking up these courses. So before going there, or for that matter, starting with a critical analysis of how these courses function, the first thing that we may consider is a somewhat similar experience to these courses, which is known to most people, which is called internships. Now, these internships are also a kind of lived-in experience. You attend court proceedings, you see court files which are taken up by the senior under his watch. You prepare generally some kind of notes, you undertake research, and a senior generally is available readily at hand to give some kind of input on your work. They may be authoritative, or they may be encouraging. It is entirely a kind of luck, which determines the kind of senior that you have. But that being said, at least you have a kind of ready reckoner to your perception of litigation, a kind of mirror image of your aspirations being reflected in a person who is readily at hand. And you can see through his lived in experiences what it is to be a litigator. The kind of emotions that one goes through, the kind of places that one visits. It is also very much a part of litigation. See, most people think litigation is about drafting, or for that matter, research. It is much more than that. It is also about knowing where the filing counter is, how much time it takes to get a matter filed and listed, what happens between filing and listing, how to remove objections, etc. These are the essence of practice, and these are the lived-in experiences of a practitioner, which are very much a part of growing into the profession. This was these courses being juxtaposed against litigation, in the sense that these courses do not have these lived-in experiences. They definitely are an enhanced version of word of mouth, but they fall short of these daily experiences of going to court, coming back, and spending probably 2 or 3 hours on the road, which is very much a part of the daily life of a practitioner. And if you think that this is not a part of litigation, you will soon discover that this is very much a part of litigation. Now, moving on, going into the detail of these courses which are there, I think the courses, the syllabus varies from course to course, which has been pointed out by you, Prem, and the scope of their inquiry into the various kinds of practice and practitioners, which is there, it varies. But that being said, there is a need to standardize these kind of courses. And I think the Bar Council of India definitely has a role to play in this matter. The Section 7 of the Advocates Act casts a clear responsibility on the Bar Council of India to take initiatives for the promotion of legal education. Now, yes, the Bar Council of India and the legal education rules of 2008 only envisage the BBLLB course and the master's course as some sort of legal education courses. But as we can now see, there are a whole host of courses, diplomas, master classes, which are also growing in the ecosystem of the legal profession. And there is a need to regulate these kind of courses as well, given the amount of fees that is being charged from candidates on this account. There needs to be some sort of answerability for the courses that are being offered, and some sort of regulation and checks and balances also. Of course, it need not be as rigorous as an undergraduate course, or for that matter, a master's course, but definitely some sort of regulation is definitely welcome as far as we are concerned. That being said, that is, we have till now touched upon internships and the legal framework which might be governing these courses. That apart, I also wanted to touch upon some things which even internships may not be able to fully prepare a practitioner for, and that is the experience of talking to a client, taking responsibility for his situation. Nothing prepares you for that largely. What you see is a client coming in front of you, pouring his or her heart out, and then you need to respond as a human being in some ways also, apart from being a repository of legal knowledge and pulling out the relevant provisions of law. You need to be humane in the approach, and I don't think anything can probably prepare you for facing another human being and taking responsibility for his troubles. It's largely a human call it goes beyond courses or for that matter rules and regulations and experiences. Sometimes a fresh client might just make you feel inadequate in terms of experience, not necessarily in terms of legal language or legal knowledge. And so you gain from these kind of experiences as well. And that is why I feel ultimately that experience matters, and the experience doing the actual thing matters more than an acquired version of these experiences, a second-hand version of these experiences. So that brings me to the last point which I wanted to emphasize, and that is that uh, these experiences are invaluable, and the fresh practitioner must make a very sincere attempt to probably gather as much lived in experiences as much as possible rather than accumulated or curated versions of these experiences, because that is invaluable. And if that is probably why senior counsels charge a lot more than junior counsels, and people generally are also prepared to pay senior counsels for these experiences. So in the initial years, the focus should not be on taking fees alone. Yes, it is important, absolutely. As a realist, anybody will tell you that it's important. But beyond certain basic necessities, taking of fees is not really the essence of the initial years of practice. It is the foundation. It is about gathering experiences and preparing for the next stage of your profession. And these experiences are invaluable. They hold you in good stead in good times, bad times, and they generally add value to the advice you give to the client who comes in after some years of experience. And I think experience matters in the end. Courses may prepare you. It is definitely an initiation which is necessary to even grasp the full strength of these experiences. But having said that, experiences are invaluable, and you can never really discount the power of these learning experiences. Yes, Prem. So that is what I had to say as far as a monologue was concerned. Is there something else that you have in mind?
Yes, I think if somebody has some questions, you can go ahead and ask your question. Huh? If they can ask. Okay, so I'll just put one question to you. If you can discuss on that point, elaborate on that point.
Sure, Prem.
The main may see this after this pandemic, they started this courses, and these courses are coming in wide varieties. A range of prices are there, and what they are targeting is this young law graduates, and this young practicing lawyers, and these have become their biggest market. And see, these courses won't be taken up by the people like who has more experience of 5 years or 7 years. So these people have become more close to this market. So you think there's something, what should these law graduates should do, especially the non-national law schools? For them, it's like, oh, you haven't learned many things in your college, so learn this thing, become a good lawyer, become high earning supreme court. See, these are selling dreams that I think that is unrealistic, and people are paying for that, especially the young lawyers and the young law graduates.
Paying for a course is not necessarily bad. Obviously, they cannot do it for free. But then there has to be some sort of moderation, some sort of regulation. It cannot be entirely left to market forces, especially when there is a professional body involved, like the Bar Council of India, which is supposed to regulate legal education in India. Section 7 is there, H&I. which govern legal education, and it is in pursuance of that the Bar Council of India has introduced the 2008 rules. But importantly, it leaves out these kind of courses from its purview. It just talks about graduate degrees and LLMs. So there's nothing beyond that, and this I feel is a lacuna, a legal vacuum, and these courses are being administered to professionals across the board. There needs to be some sort of regulation. I understand your apprehension that what is the guarantee that something might happen? What is the guarantee that the courses will cater to certain needs and expectations? Like, for example, a person might have, after undergoing a law course, you might have a certain degree of experience or at least a proficiency in handling legal disputes. But what about these courses? Absolutely, I agree that there is a genuine apprehension regarding this. But that being said, this apprehension may not be a reason to scuttle the courses entirely. It might just be a need to regulate these courses, which is more important than probably scuttling it altogether. But that being said, to answer the second part of your query regarding apprehensions about uh, national law schools and non-national law schools coming in. Yes, there is a perception which is there. But in litigation, if you see national law schools and people with stellar degrees, they haven't taken the risk to actually go on an entrepreneurial route and take up litigation. They are in the safe harbors of certain companies, large law firms. So they are not really a threat to aspirant from any law college who might come in. The real competition is between themselves, between hardworking people and people who are not. Uh, People who have a genuine commitment to reach court on time, get things on time. That is where the essential difference lies. In preparing a brief, the amount of research that you might take, the genuine amount of emotional commitment you might bring to the table while handling a client and taking up his problems into your chamber, whether for fees or without fees or whatever. So that is where the difference lies. National Law School, it's an indicator. See, there was a Nobel Prize winner called Michael Spence, who won a Nobel for the simple thing that education is intrinsically useless. It's just a signaling effect that yes, this person might just work hard, and the people who might be the recipients of this signal might think that yes, this person has bothered so much to gather so many degrees, maybe he might work hard. But if they can see it even otherwise, like when a person argues in court, like when a person gives some kind of a legal opinion, that signal is more than clear, better than probably any degree. So, and the opportunity to go to court every day, display your skill set is invaluable. I mean, that is what ultimately prepares you for litigation. Yes.
Okay, and one more thing, this courses has hyped the this practice in Supreme Court. Like, have hyped this trend that this practicing in Supreme Court is the best one. You do practice. So can you let us know, like, can you discuss more on why other courts are so important before going into the Supreme Court, and each courts have its own important role in learning for a lawyer.
See, as far as a client is concerned, uh, his experience of the judicial system is going to be determined by what his problem is. Say, for example, if there is a matter concerning electricity, he can't come to the Supreme Court directly, at least. If there is a criminal case, he might end up going to the Sessions Court or Metropolitan Magistrate, maximum to the High Court to get a bail. He can't come to the Supreme Court. So Supreme Court was envisaged as a court of appeal and a constitutional court. It was not supposed to be an elitist court or some sort of super knowledgeable court. It was supposed to be a court with a very limited mandate to handle certain important issues. But fortunately or unfortunately, how it panned out was almost all the matters travel up to the Supreme Court by way of provision under 136, Article 136 called special leave petitions. And most disputes find their closure there in 136. So, although 90% of the petitions get dismissed on the first date of hearing itself, but some travel beyond the first date. And that is where probably the skill of a lawyer might lie in the Supreme, while going to the Supreme Court. But then that being said, anybody can, that if there is a merit in the case, the judges themselves issue notice in many cases. And sometimes simply dragging the client up to the Supreme Court despite knowing that there is no merit might be a waste of the client's precious resources, because he might go and explore alternate remedies in alternate courts which are not barred by res judicata, and then continue agitating the dispute despite having lost in the High Court, etc., or some other facet of the dispute, instead of coming up in Supreme Court and wasting his resources. But that being said, sometimes it is necessary to scale up the fight to Supreme Court, because the High Courts may not have correctly appreciated the legal point. In those cases, yes. So there is no clear answer to this claim, that what is the difference between a High Court and a Supreme Court. Yes, the difference lies in the nature of the court itself to some extent. But as far as legal practitioners are concerned, it's the same. People who practice in the Supreme Court have been essentially people who have graduated up from lower courts. Those who have landed in the Supreme Court, they're good, but the doyens of the Supreme Court are those who have graduated up from the grassroots. And so it is important, basically, for young professionals to see both ends, the top and the bottom, because you will have to go from the bottom to the top, or from middle to the top, whatever it is, or sometimes even from middle to bottom. But then you need to have a good practitioner would probably be one who has capabilities across the board, civil to criminal, and from end to end, that is from the lower court till the Supreme Court. If you can see the prospect of a dispute across time and across jurisdictions, that is what makes you a visionary litigator. And I think that can be done by anyone. There's hardly any difference there. Yes.
Okay, so thank you, Joel. So I think it was a wonderful experience with you.
Same here.
So thank you everyone for joining this one.
Thank you, Fred. Bye.